Hey everyone, Harry here to talk about a new important trial of the January 6th insurrectionists. So recall the overall sweep of this. Basically, there have been nearly 1,000 people charged at this point. They first dispensed with all the kind of hangers-on. They then went at the low-hanging fruit of people who went in there. And then just recently, the department has had two major successes involving the Oath Keepers and the Proud Boys with the big ticket charge of seditious conspiracy. Very hard, and it's rare to bring. It's hard to win. They've brought it. They've won it. Victory lap, and kudos to them. Okay, so what is left? Maybe the biggest trial. There might be another seditious conspiracy. Other than that, the trial before Judge Amit Mehta in the D.C. District Court, trial court, that starts tomorrow is the big ticket item. It's against six defendants, all members of the Oath Keepers. It's just a hair's breadth under a charge of seditious conspiracy. So recall the conviction of Stuart Rhodes, the leader of the group, the swashbuckling pirate from Yale Law School with the patch on his eye. These six defendants have all been accused of basically conspiring to help him obstruct the January 6th proceedings. So they don't have seditious conspiracy, which is the prior agreement to use force to bring down the government, but they have something pretty close that they conspire with him, they help him, and they do their own actions to obstruct the January 6th proceedings. Now, this has been a bit of a circus atmosphere, which is sometimes the playbook of these insurrectionists. A little side note, if any of you who haven't heard Rachel Maddow's Ultra, it's a really fascinating account of similar episodes that many people, including I, were unaware of, involving similar kinds of insurrectionists up to and including official Washington, but trials that just basically broke down in total bedlam, and the defendant succeeded in parrying the charges with some help from a few well-placed senators and congressmen just by making it a circus. That looks to be what's going on here. Jury selection was supposed to be the first, I believe, then it was supposed to be the second, Groundhog Day. Now it is the third, Friday, and it's for all six of them. But up to there's been a whole flurry of pretrial motions, some of them a little bit silly, and I think it portends more of the same and kind of a crazy atmosphere when so many defendants are tried together. Well, let me step back. Defendants want to be tried apart, and they bring motions to sever. Why? Because if you're trying Smith and then Jones, Smith can point the finger at Jones, hopefully win, and in the second proceeding, Jones points the finger at Smith. That's what happened with Elizabeth Holmes and Theranos recently, although they both lost. In the same way, defendants want to be separate, and they've tried to be here, but the judge has denied their request. Just one of the flurry of last-minute motions was from one of the defendants saying, look, I'll take a bench trial, Your Honor. I'll be tried in front of you. That's how much not how much. There's good reasons often for having a bench trial instead of a jury. Depends what kind of case you have, if your defense is sort of legal or sort of factual. But anyway, the judge said no. So all six are there. Another defendant brought a motion saying, crowding us all around a single table. Six of us will be at the defense table. You guys have been in a courtroom probably, and there's the prosecution table nearest the jury because it bears the burden of proof. Then the defense table. All six will be there. This defendant argued it was a violation of his due process rights to be huddled with other defendants at the same table. So this all suggests we're going to have a few weeks that will try the patience of the judge, but so far he's stayed pretty cool and parried the motion and might have some crazy twists and turns. Will they try to call Donald Trump? Will there be really far-fetched motions or histrionics about the government tactics, or arguments about what one defendant has said to the other? All kinds of things, in other words, to create sideshows, try to get a mistrial, make it a circus proceeding. You know, the extreme case, as in Ultra, was it got so nuts and there was a mistrial and the government decided not even to try it again. That was extreme, obviously. Sort of a vestige of the official and improper involvement by a U.S. senator and congressman. Nevertheless, what we have here is the modern day equivalent. Just try to make it really a circus, throw anything against the wall, see what sticks. When it comes to the evidence, the government has a really strong case here, you know, videotape all kinds of statements and the like. All right, so it's a big one. Were it not for the two big seditious conspiracy trials we've already had, and that we've already gone after the leaders of both the Proud Boys, Enrique Tarrio, and the Oath Keepers, Stuart Rhodes, this would be, and still is, a marquee case. So starting with jury selection, and the thing to look for is overall defense tactics to just make it crazy, change the subject, get something bizarre happening and move for mistrial and the like. So we'll keep our eye on that, see how the strategy develops as we go into evidence in earnest early next week. Until then, talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.